Sir, കൊടുത്തിട്ടുണ്ട് ഇപ്പം started.
Yes. Started. It has started. Yes. Greetings, Johnson sir. Greetings, sir.
Sir. Thank you. Good evening, sir.
Yes, Mr. Johnson and all others.
Yes.
Dear all, we have. It is time to start the session. To all participants, kindly mute yourself and switch on your camera while listening to the presentation. The presentation will last for 45 minutes, and the remaining 50 minutes will be used for Q&A session. This is the academic session of Project Complete Lawyer. I am the convener, SANDEEP.C. Project Complete Lawyer is an initiative to train final year law graduates to become successful lawyers within a span of 2 years after their graduation. That is the intention, aim, and objective of Project Complete Lawyer. This has been launched in 2020, and it has been initiated by Law and Justice Research Foundation and Cochin Institute of International Arbitration. We conduct clinical exercises discussing case laws, scenarios where you have to interact with the different types of law in relation to a particular institution. The current institution that we are focusing is on the institution of high courts, the High Court of Kerala. And in relation to this, we in Project Complete Lawyer, we have explored a myriad of subject matters. This clinical exercise that we are conducting is one of the many clinical exercises that we have conducted. So in order to invite the guest for today and to introduce the guest to all the participants, I invite the chairman of Project Complete Lawyer, Advocate Johnson Gomez. Sir, back to you. Johnson, sir. Johnson, sir. My apologies, everyone. Johnson, sir, due to some technical reasons, he is. Yes.
Good evening, everybody. Now, today we have a session on administrative law principles and practice, and the speaker of this session is Advocate M.R. Rajendran Nair, Senior Advocate, Designated Senior Advocate of the Kerala High Court. M.R. Rajendran Nair സാറിനെ പറ്റിയിട്ട് പറയണമെങ്കിൽ മലയാളത്തിൽ പറയുന്നതായിരിക്കും ഏറ്റവും നല്ലത്. കാരണം ഞാൻ 1999 1999 2000 പീരീഡിൽ ഹൈക്കോടതിയിൽ വരുന്ന സമയത്ത് MR രാജേന്ദ്രൻ സാറ് കോടതിയിൽ പോയിട്ടില്ലെന്നുണ്ടെങ്കിൽ ഒരു കോടതി വർക്ക് ചെയ്യത്തില്ല. ആ കോടതിയുടെ പേരാണ് സെൻട്രൽ അഡ്മിനിസ്ട്രേറ്റീവ് ട്രൈബ്യൂണൽ. കാരണം ഒരു ഭാഗത്തുള്ള എല്ലാ കേസുകളും സാറായിരുന്നു. പെറ്റീഷണേഴ്സിന് വേണ്ടിയിട്ടുള്ള സകല കേസിനകത്തും സാറുണ്ടാവും. ഇതിനിടയ്ക്ക് 2-3 എണ്ണം മിസ് ചെയ്ത് വേറെ ആരെങ്കിലും ഫയൽ ചെയ്യുന്നുണ്ടെങ്കിലേ ഉള്ളൂ. അതർവൈസ് സെൻട്രൽ അഡ്മിനിസ്ട്രേറ്റീവ് ട്രൈബ്യൂണലിലെ ഒരു പീരീഡിൽ സാറ് ചെന്നില്ലെങ്കിൽ അന്ന് കോടതി വെറുതെ ആയിരിക്കണേ. അതേമാതിരത്തുള്ള ഒരു സിറ്റുവേഷൻ ഉണ്ടായിരുന്നു, ഒരു കാലം ഉണ്ടായിരുന്നു. അപ്പം വി ആർ ടോക്കിംഗ് ടുഡേ വി ഹാവ് എ സ്പീക്കർ ഓൺ അഡ്മിനിസ്ട്രേറ്റീവ് ലോ ഹു ഈസ് എൻ എക്സ്പേർട്ട്. പിന്നെ സാറിന്റെ വേറൊരു ക്വാളിറ്റി ഞങ്ങൾ കണ്ടിട്ടുള്ളത്, ഏറ്റവും ബ്രീഫായിട്ടുള്ള പെറ്റീഷൻസ് ആണ് സാർ എഴുതുക. ഒരു പോയിന്റേ ഉണ്ടാവുള്ളൂ, ആ പോയിന്റ് കേസ് ജയിച്ചിരിക്കും. കോടതിയിൽ സംസാരിക്കുമ്പോഴും അത്തരത്തിലാണ്. സാറിന് ഇപ്പോഴും നമ്മൾ പല സീനിയർ എൻഗേജ്മെന്റ്സും സാറിനെ ഏൽപ്പിക്കുമ്പോഴും ഒരു പർട്ടിക്കുലർ പോയിന്റ് മാത്രം സാറ് ഡെവലപ്പ് ചെയ്യും. ആ പോയിന്റ് ജഡ്ജി അവസാനം അംഗീകരിക്കും. ആ തരത്തിലുള്ള ഒരു വളരെ എക്സ്പെർട്ടൈസ് ഉള്ള ഒരു ലോയറാണ് നമ്മളുടെ ഈ പ്രോഗ്രാമിന് വന്നിട്ടുള്ളത്. സാറുമായിട്ട് ഈ കോൺസെപ്റ്റ് ഞങ്ങൾ പണ്ട് ഇത് പ്രോജക്റ്റ് സ്റ്റാർട്ട് ചെയ്യുന്നതിന് മുമ്പ് തന്നെ പലപ്പോഴും സംസാരിച്ചിട്ടുണ്ട്. And he was always very happy and enthusiastic about this particular project. Especially this project is developed from the speeches and writings of Professor Dr. N.R. Menon. Menon സാറുമായിട്ടും സാറ് വളരെയധികം അടുത്ത് ഇടപെട്ടിട്ടുണ്ട്. ഒരുമിച്ച് പ്രവർത്തിക്കാനായിട്ടുള്ള ഒരു സാഹചര്യമൊക്കെ ഉണ്ടായിട്ടുണ്ട്. So I welcome Senior Advocate M.R. Rajendran Nair sir to make his presentation. Thank you.
Thank you, Mr. Johnson Gomez. I'm indeed privileged to be here in the project Complete Lawyer to give my views on administrative law principles and practice. I bow my heads before our great scholar, Sri N.R. Menon, who saw the seeds in our mind for developing a project like this Complete Lawyer. Sri N.R. Menon has rendered distinct service to the legal profession. Whereas I consider my standing at the bar, I owe much to him, because on many occasions we had to work together for taking classes. Sri N.R. Menon wanted to develop law, people-friendly law, and he was always having the vision. Law is for the people, because most democratic setup, when we speak about the government of the people, by the people, and for the people, etc., the law must be for the people. And I am indeed happy today to give my views on this subject, and I bow before him once again. Administrative law, principles and practice, is comparatively a new law, in the sense, in the country from where we have borrowed the legal principles, namely Great Britain, England, there was absolutely no recognition for administrative law till late, if I may say so, till 1971. Because it was for the first time in 1971 in Breen versus Amalgamated Engineering Union was the first case where the existence of administrative law was recognized in the United States, in the United Kingdom for the first time. Because A.B. Dicey, as all of us know, you have heard of A.B. Dicey. Albert Van Dicey, he was a British jurist. He said only one law, that is common law, applicable to all uniformly. For that reason, that was in 1885. For that reason, administrative law was rejected, practically rejected as a concept in England. The numerous statutory discretionary powers given to the executive and administrative authorities and control, etc., was practically not recognized. I don't say it was not there. But coming to our small India or state, I would say, though these things came in England sometime in 1971, and all over in other places we say it emerged in 1914, etc. That is the scholarly output by given somebody. 1914 is some date is there. When the country, the world changed from the laissez-faire system to a welfare system, need for administrative law emerged. Today, all of us know our state, rather the government is not only the policeman. Government is not only the currency man. Government is everything. Government is your bread provider, house provider, education provider. Government is practically providing everything. Therefore, in every aspect of your life, administration comes in. And therefore, since we are governed by rule of law, administrative law is the only law which touches the citizen, which touches the human being at every aspect of his life. Then can any one of you say which is the statutory provision for administrative law? We have a civil procedure code, we have a criminal procedure code, we have a contract act, we have transfer of property act, we have a easement act, and 101 other legislations. We have Constitution of India. Is there any statutory enactment which governs the field of administrative law? Any one of my friends can unmute and say. Everybody is silent. Administrative law, there is no textbook. I don't say there is no textbook. There is no statutory provision. You will find every statutory provision is there, but administrative law as such is not a legislated law. To be very brief, I would say it is a judge-made law. Whenever administrative function, administrative duty, or administrative action was challenged before a court of law, in the process of judicial review, very important words, judicial review, courts invented and applied grounds for judicial review. And slowly and steadily, administrative law developed. This is what I may very briefly say about the evolvement of administrative law. I have experienced the impact of administrative law as early as I was in the pre-university class. Some anecdotes will be required. The pre-university class, I went to the SD College, Sanatana Dharma College, Alappuzha. I was a very punctual student because I have learned, later only I have learned from Sri N.R. Menon, punctuality is the most essential equipment which a lawyer needs. As a matter of fact, I was very punctual. Mr. Johnson knows whenever I am asked to help him, I will be by his side at least 10 minutes ahead of the time. Today also I was here 10 minutes ahead of your scheduled time of 8. Because I am told by eminent persons, punctuality, integrity, professionalism, and social commitment are the sine qua non of a successful lawyer. That is true in the case of any successful man, whether you are a merchant, whether you are a butcher, whether you are a musician. Punctuality, integrity, professionalism, and social commitments are needed. Here again, I would emphasize When I went to the pre-university class, I was very punctual, I said. Professor B.J. Baliga, who was a resident of Alappuzha, very dwarf man in a long jubba. He comes to the class, declares the law regarding the class. 2 laws he declares every day. He says a seat for every student and a student for every seat. That means there should not be a change of seat. You should sit in the class according to your roll numbers. A seat for every student and a student for every seat. Then he declares only one voice must be heard in the class. Either I speak or you speak. In other words, if anybody speaks when I am lecturing, you will be out of the class. That is the declared law. I happen to be in the backmost row on the basis of the roll numbers. I was not able to listen to him properly. In fact, I wanted to listen. I took the courage of meeting him in the teacher's room and told him, sir, I am in the backmost row. You are not allowing to change my seat. You say a seat for every student and a student for every seat. But I am not able to hear you properly because of the murmuring and whispering in the backmost rows. This is what I said. Yes, he said. Immediately the decision comes for a reason. When I presented my case with the reason, he gives me a verdict on the spot. Yes, you come to the front seat tomorrow. Normally impermissible act. I now consider he was the greatest administrator ever I have found. Whenever there is a reason to interfere, he interferes and even bends or amends the law and invites me to sit in the bench. Because the purpose of his law, purpose of his rule is to give every man his due. Next day, I sat in the front bench. Of course, my friends said, oh, yes, I have muscade, I have kaimani addition. So people started wondering how this can happen. In a class of B.J. Baliga, nobody will be able to change the seat. But I got it changed. Perhaps I started my practice of administrative law in 1961, if I may so, without knowing that it is the administrative law principle. If you assign reason, if you give reason and justification, any hardened administrator will change the law for you. Because law, there is no parliament made law for that. It is a discretion of the judge. That discretion is not mere humor, because you are read a lot regarding administration. Discretion is not a humor. It is the exercise of power on just principles. Yes, I have another experience in the college, which should be narrated for your. I continued my studies, and by the final year time, I got a small employment in central government service. Because of practically poverty, it was my fate to accept a small job and leave my studies in the final year BSc. I left the class on July 15th. You know, June 1st, the classes opened. July 15th, I left for 2 months training. Went to Trivandrum. Broke the class. Fortunately, I was appointed in Alappuzha, 2 kilometers away from the college. Then I got the opportunity to continue my education without taking leave or without forfeiting the employment. I went to the college expressing my desire to continue studies. The office said, oh, you cannot continue. 2 months you were absent. Long continuous absence. You are liable to be removed. This is what the office superintendent said. Straight away, the very strict man, A.V. Akhileshwara Iyer, principal of the SD college. I wanted to meet him. I was given an appointment. I told him, sir, I want to continue my studies. I was continuously absent for 2 months. Then he asked, why? I explained the truth. I wish to learn. I wish to continue. Yes, LJRF asked a question to the office superintendent. Is his name removed from the rolls? They said, truly, no. If his name is not removed from the rolls, he is entitled to continue, subject to his paying the fees. Yes, I give him a week's time to pay the fees. Perhaps nowadays you may obtain such an order from the High Court of Kerala under Article 226. But my principal LJRF in 1964 gave me this verdict for one sentence argument. He administered law justly, fairly, and reasonably. And therefore, I am here after my BSc, then later my BL from the law college also. In the law college also, I should narrate 2 episodes. By the time I got a transfer from Alleppey to Ernakulam, keeping my employment, searching for some higher education, I found that Ernakulam Law College was nearest to the telephone exchange. After exhausting my attempt to get an English MA or Hindi MA, etc., though I was qualified for that, finally I chose FL. First, I am a 2-year law student, FL and BL. 66, I made an application for FL application. I was invited by the principal for a cross-examination. Mr. Rajendran Nair, your application is incomplete. You are not filled up column number 17. I said, sir, deliberately so. Because honestly, I said, I have not filled up. Then why? I cannot fill it up because your question is 2 questions are there. Are you employed? If so, are you producing a relieving certificate? No, sir, I will not be able to produce a relieving certificate. But I don't want to tell a lie. I am employed. If I write no, it will be a lie. If I write nil, it will be a misrepresentation. Principal told me, since you are an honest man, I give you admission. You produce a NOC from your employer. Then I go to my Fernandez assistant engineer, whom I have met earlier, and requested for liberal duty exchange so that I can prosecute my studies by undergoing evening duty, night duty, etc. There, again, another episode. Fernandez tells the office superintendent to issue NOC on my application. So office superintendent comes and says, sir, there is no provision to grant an NOC. Fernandez, a dwarf Anglo-Indian blackish man, retorts, no, his very purpose of his coming here on transfer from his native place, Kayangulam, to Cochin is to prosecute his studies. And I have promised to give him all facilities. You issue that. Sir, there is no provision. The question by the Anglo-Indian assistant engineer, a small officer, was, is there any provision preventing grant of such an NOC? That is the greatest principle of administrative law which I have ever applied in my practice after getting the law degree and after starting practice here. If there is a provision, if there is no provision prohibiting the exercise of a liberal, fair power for advancing the cause of justice, any administrator is entitled to follow that. This is the principle of administrative law. Without knowing that it is administrative law, without learning administrative law, I have experienced such great principles of administrative law being applied in my life. And thereafter, I have also made every administrator to learn administrative law and apply administrative law only consistent with the rule of law. Now I tell you, the basic principle of administrative law is only rule of law. What is rule of law? Rule of law is rule of law and not rule of man. What we find nowadays in every office or in every institution, rule of law is absent and rule of man prevails, and that results in corruption. You have heard Lord Acton saying, power corrupts. And absolute power corrupts absolutely. And therefore, I would say there is absolutely no absolute power in law. There is absolutely no absolute power, at least in administrative law. And there is nothing but administrative law. Whenever I have started practice, whether it is criminal law, whether it is civil law, whether it is contract law, whether it is property law, whether it is matrimonial law, I was able to see a ray of administrative law in every aspect of rule of law practice. You may wonder how it is. Because you are all well versed with the textbook of administrative law, I will not refer to textbooks straight away. I will tell from my own experience. You know, one of the greatest principle of administrative law is that the reason of the administrator, quasi-judicial officer, or a judicial officer should contain order should contain the reasons. That is the one principle. That is, of course, third principle. I am taking the third principle as first principle. In 1986 April, I went to the Ankamadi police station. That was a day when my one driver from Tamil Nadu was caught up while for a hit and run case. Somebody was killed. Suspecting that the lorry driven by my client was the vehicle involved. The vehicle was seized. The driver was also about to be arrested. I went to the Ankamali police station asking for bail of the driver in that accident case. 304A IPC is the offense, all of you know by this time. But it is a bailable offense. That perhaps you should know. Bailable offense means the police station also they can grant bail. But I went to police station, the police inspector was telling me, sir, I cannot give you the bail in this case because my superintendent of police has issued an order not to grant bail in motor accident cases involving death. I just wanted to see the order. Police Circle Inspector Van Balakrishnan gave me the order. I just had a smile on my lips and told the CIIA, yes, this order is dated 1st April 1986. I see that. Very fit that such an order can be issued better on 1st April because it's a fool's day. This is a foolery. But then CIIA was telling me, sir, so you can say so, but I will have to obey my superintendent of police. I will not grant bail. I went to the magistrate court, Alway. One Mr. Rajan, who was the magistrate, who was copyist in the High Court, later on came as a magistrate in Ernakulam. I was very friendly with him. I made an application. Accepted my application and signed. He said, no, 304A case, I cannot grant bail unless the police arrest him and produce. This is what the magistrate told me, right or wrong. Because you have come here, I will not remand your client. I will return this application. You take it. Please come when the police arrests and produces. I said, no, I will not accept it back. I have given an application to you. You have signed it by your green pen, green ink. You have accepted that. Now I will go only with an order. I insisted. I will go back to Ernakulam only with an order. You may grant bail or you may dismiss the application and remand the accused. And I will go with a credit that I am a lawyer from the High Court of Kerala who got a remand order from the Magistrate Court Alway in a bailable offense. Magistrate was worried. How can he remand in a bailable offense? Finally, he agreed to grant bail on condition that I will not divulge it any of the colleagues, members in the bar. I said, I have a lot of other work to do. I will not be sitting here to discuss this. But I will tell this. throughout my life. I promised him, and I am doing it. Because I was sure my state will not be able to remand it, because my state should show reasons for that. In available offense, they should know. That is practically part of administrative law. That is what I want in it. Whether you are practicing criminal law, whether you are practicing contract law, whether you are practicing. See, now, today we can very administrative law is statutorily recognized in India. Statutorily recognized in Kerala. How it is possible to say so? Because the 2005 Act of Right to Information Act 2005, there's a provision in section 4 which mandates that every administrative order must contain the reasons thereof. Till that day, the duty to give reasons, in other words, the duty to pass only speaking orders. No, the order should speak for itself. It should be a speaking order. If it is not a speaking order, as just Mr. Johnson was suggesting it, I need to stand up in the court of law and say that a cryptic order is passed. A cryptic order means an order without any reason. Mere ipse dixit of the administrator. No court will waste time. They will immediately quash it. You cannot pass an order without reasons. That was the administratively evolved law till 2005 in India. But in 2005 in India, Right to Information Act 2005 mandates that every administrative order should have reasons. Many lawyers do not quote this provision because they are in the habit of borrowing the old pattern of thinking the order is without reason. Hereafter, you can definitely look at section 4 of the Right to Information Act. The statute provides for that, and the order without reason is violative of not only natural justice, is violative of the statutory provision also. As you know, in a judicial review matter, you can take the contention of ultra vires. The order is ultra vires, the rules. So it is very, further when we come to Kerala, much before 2005, 1999 Act of Kerala Lokayukta Act, 1990. The Kerala Lokayukta Act 1990, it was an offshoot of an ordinance in 1998 when Mr. NAIR was ruling the Kerala. There, action was defined. The Lokayukta Act, action was defined. Means an action including administrative action taken by way of decision. You see how beautifully the administrative action is defined as an action. Administrative action taken by way of decision, recommendation, or finding, or in any other manner, and includes willful failure or omission to act, and all other expressions relating to such action shall be construed accordingly. This is what the definition of action in the 1999 Lokayukta Act. Further, in the very same act, the maladministration, we are at the administrative law, principles and practice. Maladministration is the evil of the day. Maladministration is where you will be, if you practice maladministration, what will happen? You will go to jail. You will lose your position. And for that reason, at least one of our ministers last year had to vacate his seat. All those controversies are there. Now that part of the act is being amended by the legislature, initially by an ordinance, and later on it will come up for discussion. Much discussion will take place. But maladministration definition is not changed. Maladministration means action taken or purporting to have been taken in exercise of administrative functions in case where such action or administrative procedure or practice adopted in such action is unreasonable, unjust, oppressive, or improperly discriminatory. The simple word maladministration. Whenever an action, or rather action includes omission also, whenever an action or omission is unreasonable, unjust, oppressive, or improperly discriminatory, that is maladministration. Whenever there has been willful negligence or undue delay in taking such an action, or the administrative procedure or practice adopted in such action involves undue delay, then it is a maladministration. Maladministration is an actionable wrong. Unreasonable delay itself will make the action maladministration. What a beautiful law. You know, perhaps many of might have practiced successfully in that area. Even delay in payment of pension, delay in payment of salary, normally that are the cases coming in there, has been interfered with by the Lokayukta on the ground that it amounts to maladministration. And I'm sorry to say that our lawyers rarely use this provision to help the people. There are innumerable instances where Kerala Lokayukta Act, even after amendment, can be utilized for getting the benefits. I don't elaborate on provision. There is provision for granting compensation also. In other words, if an administrative action is delayed unreasonably and unjustly, the victim is entitled to get compensation. You might be thinking compensation is available only in a vehicle accident case under the MSCT. No. Even if the administrator delays it, even if the municipal corporation or panchayats or the private court, because there the opposite parties are private school managers, cooperative society, panchayat, everybody is included. That is a very, we should learn that law separately. You are entitled to get compensation for unreasonable delay in acting on your requirements of welfare state. And what more? Thus, the administrative law has grown, of course, recently born and grown in a very, very, very wide manner all over the world, India and particularly. See, all these ombudsman, everything you know, it was the contribution of Scandinavian countries which led to the development of administrative law. We have ombudsman for the local self-government organizations. We have ombudsman for banking. We have ombudsman several places. And now that we are always thinking regarding alternate dispute resolution mechanism, including arbitration, conciliation, and mediation, and the latest Act of 2019, Act of what we call the Consumer Protection Law. Latest law provides for mediation also. All these are ramifications of development of administrative law. So today, I need not elaborate on the principles of administrative law to a larger extent, because all of you have come across that, perhaps without realizing that these are administrative law principles. You are practicing it also successfully. Then I will mention something regarding the practice of that. See, to me, whenever a matter comes before me, this is one procedure which suits me. I immediately ask which is the provision which hits you. Even if it is a client coming or a lawyer coming for engaging me as a senior advocate, even before listening to the history or story and shedding tears hearing the story, I ask, which is the order which hits you, whether it is passed by and who has passed it. Normally, the order will be passed by a Tahsildar or a district collector or a secretary to government or a vice chancellor or a registrar or a judge, sub-court, municipal court. Which is the order? We read the order first. I'm mentioning something regarding principles of practice. Then when you read the order, your attention must go to the last portion of that order to see who has signed it or who has issued it. Our Kerala government orders are issued under orders from governor, and it will be signed by a deputy secretary or a under secretary or a section officer. Even President of India order will be signed by the desk officer there. We see that. But on how it is issued, what is the office procedure, what is the manual of office procedure, etc., you should learn separate. You should find out whether that order is issued with the jurisdiction. Question is whether the order is within the jurisdiction of the person who has issued it. Once you are satisfied with the jurisdiction, perhaps you can give a goodbye to that sort of inquiry. Otherwise, the first ground must be the impugned order is without jurisdiction. Even if it is with jurisdiction, you may say so. Sometimes it may turn to be without jurisdiction after some more research. But that ground must be taken. And assume that it is with jurisdiction. Then the law with jurisdiction also should be after complying with a certain procedure. Look at the impugned order, judgment, or direction, whatever that be. Find out whether it affects you adversely, whether it has any civil consequences. Suppose an order is issued just like an advisory that you should walk through the left portion of the highway where the vehicle is running. Just like our street laws, you should walk on the left side because the vehicle, and you should walk on the right side. Vehicle is coming through the left side, like that. It's only an advisory. It is only an advisory, and even if you walk on the wrong side, you will not be punished. But except advisories, if the law mandates you to follow some at the risk of being penalized, then you should consider whether the law, whether the order, administrative order is passed after due compliance with the procedure prescribed for that. Every procedural law will prescribe a procedure. And even if no procedure is fixed by any law, we lawyers of administrative law lawyers, constitutional law lawyers would argue that the procedure of principles of natural justice must be followed. That is where we then we look whether we had an opportunity of being heard. Suppose the order penalizes you, suppose it punishes you. Question is whether you were heard, because three principles of administrative law always all of us have in mind. No one shall be punished unheard. No man shall be a judge in his own cause. And all your orders must be speaking order. You should give reasons. These are the three principles, and there are much more principles are there. Now, every day we are evolving new principles. But these important principles are there. Looking at the order, you can find out whether it is a cryptic order or with reasons. And if you are not given a notice, and if you are not afforded with an opportunity of being heard, it is the violation of from partem. And the order is passed by the person being a judge in his own cause. Suppose an order is passed by the Tahsildar for saying that Tahsildar was given a beating, therefore I punish you. Like that. Except in the case of contempt of court, no one is entitled to be a complainant and judge in his own cause, which of course we demur. Such a provision we demur, because we give high position to the High Court and Supreme Court. They are dealing with the contempt of court. And the contempt of court procedure is a procedure where practically, judge and the complainant will be same. But we will argue, whenever I argue for the court, or I say it is, we are upholding the judicial independence, not the judges. We are not vindicating the rights of the judges, for which they will go for defamation suit, etc. Anyway, no one shall be a judge in his own cause, and no one shall be punished unheard, and every order should be containing the reasons thereof. And after these grounds, we have got other grounds of attack also. Excess or failure to exercise jurisdiction. You cannot exceed, because if you pour some water in a glass, if you continue to pour even after the glass is full, what will happen? It will overflow, and it will result in waste, and it will dirty the dining table. Like that, if you have got a power, you utilize it to the maximum limit to which it is utilized. Excess of jurisdiction is a dangerous exercise. And non-exercise also. Non-exercise also. Not giving the man his due. Justice means giving every man his due. I will not do that. Delaying it. I said that delaying it also is a maladministration. Yes, violation of natural justice, I told you. Violation of fundamental rights. All those things has to be examined in order to make up a successful practice in the courtroom when you deal with administrative law principles. The administrative law as such is developed as a judge-made law for the reason that proliferation of legislations makes our legislature incompetent to legislate on all fields. Incapable because lack of time. Legislative time is less, and details cannot be worked out. And that is the reason for development of administrative law. And I will now conclude my saying that there is absolutely no absolute power. That is, earlier also I told. And if you bear in your mind that principle, no power is absolute. Why? I will immediately say every power is coupled with a duty to exercise that power in a just, fair, and reasonable manner. And the ultimate requirement of administrative law practice will be to persuade the judge to demonstrate that your client is visited with an unfair attitude. Fairness in action. Fairness in action is the requirement of the day whenever we practice constitutional or administrative law. And you will be able to demonstrate that the administrative authority acted unfairly because, how do you say so? Easy to say so. He has taken into consideration irrelevant materials. He has not considered relevant materials. He has concluded first, then came to reasons. All those things, so many areas of challenging the administrative order is there. And when you read every textbook, you will find all those grounds available. Only thing, it is not the existence of grounds for attack which matters. It is exercise of your discretion to put the grounds into action. What is the use of you are having a weapon if you don't know how to use it? just like we read in the news nowadays, every citizen in one country is now being given the weapon. If they don't know to use it, it will be a heavy weight for them to even for moving. And the use of law will be very minimal unless you know how to utilize it. And I conclude by saying when the judicial control of administrative action is an area where we practice the principles of administration only for the purpose of judicial control. Otherwise, there is nothing. You, as a citizen, you can go and ask the administrator to accept your petition and give me an answer. He may give an answer. If he gives an answer without any reasons, that is velvet, good for a lawyer, because immediately that order will be set aside. For the citizen, it will be very bad also. We don't know. Anyway, I just narrated the 8 principles of administrative grounds for challenging the administrative action in a judicial review and conclude this narration for the time being, because if I go at this strain, even after 3 hours, it cannot be a complete thing. I just read out. If the administrative legislation is ultra vires the constitution, because in our constitution we have got the fundamental rights, we have got the fundamental duties, we have got the directive principles of state policy, and you should learn how to convert the directive principles as a fundamental right whenever it is needed. Then, if the administrative legislation is ultra vires the parent act, suppose there is a parent act like Land Conservancy Act, like Contract Act, and if the administrative act is under that act, whether it violates the provisions of the act or rules there under, you should see. That's all. Then, if the administrative legislation is arbitrary, unreasonable, and discriminatory, no arbitrary action is permitted. That is why when I went to the law English professor, it's an arbitrary decision of every seat must be filled by the student, even when he is not able to hear. He himself corrected it. Such an arbitrary action will not lie. It should be just, fair, and reasonable. Arbitrariness is the antithesis of rule of law. Arbitrariness is the antithesis of rule of law. And unreasonableness is also a ground for challenging the administrative action. Discrimination. One law for Johnson Gomez and another law for Rajendran Nair will not lie, because we are not that way distinct. We are all human beings. So we should be governed by the same law, not necessarily the same way approach. That depends on the offense committed. Law must be the same. There cannot be a discriminatory action. If administration is a mala fide, research and find out what is mala fide. Mala fide, exercise of power, is exercise of power, generally I would say, for a purpose other than for which it is conferred. If you exercise power for a purpose other than for which it is conferred, it is mala fide, exercise of power. It is simply said. If the administrative legislation encroaches upon the rights of private decision derived from the common law, absence of an express authority of the parent act, that is acting without jurisdiction. Without the express authority by the parent act, you cannot deprive the citizen of any legal right, any assets. If the administrative legislation is in conflict with another statute, suppose a statute is there and administrative action violates with that statute, then also you can challenge it. If the administrative action is power of legislating the authorities to legislate the rule, power is administrative legislation is vague. And we may even challenge the administrative action on the ground the rule authorizing it is vague, because vagueness results in injustice. The purpose of law and purpose of court practice is to give every man his due, that is called justice. And justice is reflected in our constitution, where it is in the preamble of our constitution. Justice of all types is a fundamental law of the country. And by understanding the principles of administrative law, and going ahead with all sorts of your practice, bearing in mind those principles, definitely you will be a complete lawyer. If you have any doubt, you can question me. I am amenable to answer within the limits of my knowledge, because no knowledge is unlimited. I know those who heard me are having better knowledge because you are of recent origin. I am an old stock. Now you are of recent development is with you. Thank you very much. Now I conclude here.
Thank you, Rajendra sir. Thank you so much for the wonderful presentation. Now, without any delay, we move on to the Q&A session. Before raising the question, kindly introduce yourself, then ask the question. And along with the questions, you can also make comments on the presentation. If you have any thoughts or any reflections that might have came to your mind, you can also share in the platform if you don't have any questions at all. So all participants are welcome to raise the questions or make reflections on the presentation made by Rajendran sir.
We have Prashant sir joining from Bangalore. I think that I believe that he may have some thoughts on what Rajendran sir was presenting. Sir, are you there?
Yes, I'm there, and thank you so much for that. I just came in as a listener, so I don't necessarily have questions. But there's a point that I wish to agree with our guest today, and that is that the principles of administrative law, irrespective of there being no statute, is possibly at the foundation of whatever we deal with. So, and in fact, these are principles which are not complicated, which are based on reasonableness, fairness, non-discrimination, non-arbitrariness, and things like that. So I totally agree with sir. I totally agree with Sri M.R. Rajendran Nair sir that wherever you go in law, you see these principles. Whether you're challenging a tender matter in the High Court, whether you are challenging a service matter, whether you are, taking up a service matter, whatever you take up, this principle of these principles are extremely relevant, and the semblance of the same are the foundations of our jurisprudence, and principles like avoidance of administrative malice, principles like avoidance of arbitrariness, that no man can act as a judge in his own cause, that natural justice will have to be adhered to, and things like that will find its application everywhere. For instance, very recently, somebody came and told me that as a technology provider, that company was partnering with various companies to submit bids in a public procurement matter, in a tender matter by a governmental authority. Now, the governmental authority, when there were two particular technologies, the governmental authority, having come up with a tender which could accept both the technologies, consciously issued a corrigendum changing the character of the tender and thereby excluding one kind of technology. Now, this happened once, next time also it happened. And then they realized that while there is no law that says that the authority which floats the tender cannot change the terms of the tender, this is a conscious change that they have adopted only to exclude the players in one particular technology and to that extent benefit the competitors who only manufacture the other kind of technology. So if you look at it, what is wrong? It's an administrative authority, and that authority has the power to come up with its own norms. But here, the authority came up with certain norms and then went back on it, and then in a manner which is arbitrary, excluded a competitive technology which is beneficial for the public. So the whole point is there is public money involved when a governmental authority acts, and using that public money, even if there is no other statutory law, can you discriminate between two players, thereby minimizing the benefit to the public? So things like this are challenged not based on statute but based on arguments of probity in conduct and transparency in conduct. So I think it is very important for our participants, as Sir rightly said, I think it's very important for our participants to acquire as much as possible the flavor of some of the fundamental principles of administrative law wherever they go. I mean, they may be, in fact, I would say that even if you act within the realm of a pure private contract where two parties consciously enter into a contract, and therefore an argument that the said contract can't be changed by the judge, because judge is nobody to make a contract. Judge can only interpret the contract at best. Even there, when you, for instance, under 23 of Contract Act, challenge the contract as opposed to conscience, you have a great deal of advantage if you have a great depth of understanding of administrative law. So it's not merely in state versus individual situation. It is even in matters where there are two private parties, where there is no state, and there is a challenge made to a certain written letter of law, that the great deal of knowledge of administrative law and its fundamental principles will help somebody a great deal. So that's all I want to say. I mean, it's very general. I mean, one can go on and on and on various things, and particularly various principles on 226 and things like that. But today, for instance, who is an arm of the state or who discharges public policy, even if you are not an arm of the state for the purpose of 226, who discharges public policy is a constant confusion. Recently, I was defending a company which is a purely private company, but an argument was raised that the company was placed in special economic zone, and being placed in special economic zone, it gets various tax benefits. It also gets it also attracts the provisions of the special economic zone statute, and thereby is it discharging a statutory function, thereby invoking the principles of Article 226 and inviting the jurisdiction of the High Court. So things like that, these are things which keep evolving despite our attempt to create a composite set of principles. It always escapes such attempt, and new principles keep emerging. And therefore, I think it's very, very important to understand these cardinal principles, because at the end of the day, these are the principles of egalitarianism, these are the principles of equanimity, and these are the principles of probity, which are very, very important whether you deal with public law or whether you deal with private law. And I think to that extent, it's very, very important to constantly go back to the theories of administrative law and to understand where in respect of each transaction one stands. That's all I want to say. So I only have very general observations. Thank you.
Thank you, Prashant sir. Now, participants can raise your queries to Rajendran sir, or you can even make your comments, your understandings, whatever it is. I believe that it should be a participatory session. So
Students, if it is not a question, you can also share your reflection that you have received from the facilities. Any comments? Well, all are welcome. Anyone? മലയാളത്തിലായാലും
Yes.
കുഴപ്പമില്ല. You see, you can give your feedback in Malayalam as well. You don't need to speak in English. That's not
Can I just add one thing, because I forgot to say that I'm not necessarily on the topic here. I just want to say that I'm particularly very overwhelmed to hear Sri Rajendran Nair refer to my guru, Dr. Madhav Menon, because I just forgot to add that. I mean, I have a great sense of, I'm deeply touched and honored whenever I hear anybody refer to the great soul, because he's practically the only person who, in a towering manner, changed the entire legal scenario of the country, legal education scenario of the country. So, I mean, Sri Rajendran Nair, of course, somebody like Mr. Rajendran Nair is extremely eminent. I know, I mean, he wouldn't remember me, but of course, when he came over to Delhi for a brief while, I was practicing in Supreme Court, and I had occasion to meet him several times in the Supreme Court and also at the Guruvayur temple in Mayur Vihar. And of course, I know his son. I had in fact even attended his wedding. I remember many years back in TDM Hall, where since his son was very active conducting programs in the Ernakulam Law College, I had occasion to represent Tevara College and participate in many such programs when he conducted. So at a personal level, I hold Sri M.R. Rajendran Nair and his family and the NGO. I'm forgetting the name. I used to know this earlier. And the organization that Samiksha.
Samadha Law Society.
Samadha Law Society. In great admiration right from my college days. I've been observing them, and I've been in great admiration for the whole family. So, sir, to hear from you these words of admiration for Dr. N.R. Madhav Menon is really heartwarming. I know that you are one of the persons because of whom that program was conducted by Johnson sir and others in the Ernakulam High Court when Dr. N.R. Madhav Menon passed away, where Mr. K.K. Venugopal came and participated. I know that you were inspirational in the conducting of that program. So that's one thing I wanted to add. And I urge our audience to make the best of this opportunity to interact with a doyen of your bar. People like Sri M.R. Rajendran Nair, who have been for decades ruling the Kerala bar as the doyen, when they come so kindly and willingly to participate and to interact with you, please make the best of it, because they represent that wealth of knowledge and that classic way of legal practice, which perhaps is fast vanishing in a world where we try to replace deep learning with quick technology and some principles, some age-old principles, which with quicker way of earning money and things like that. So when we have somebody as eminent, as towering as Mr. M.R. Rajendran Nair, I urge our audience to please make the best of it. Even if it is outside this topic, even if you are not speaking in English, please make the best of it and interact with him. That's a personal request that I have.
Sir, you finished your presentation on the correct time. That is 45 minutes. I thought I should let you know. You kept your time. I was tracking the time through and through.
I think that Aksha had a question. Aksha.
Yes, sir. Sir, I am Aksha,
Yeah.
one of the PCL members. And first of all, your session was very beautiful, and you have dealt this topic very beautifully, because you have shared your experience with the topic, and you have connected or related your experience to this topic. So as an audience, you seek all the attention of our audience. And my question is that you have mentioned about rule of man, and instead of rule of law, we are sometimes we are seeing rule of man. And how far it acts as a hindrance to the actual purpose or the actual aim of the administrative law? That is my question. And also, in some cases, the people are not aware of whether it is a right decision or the what kind of remedy are available to them, and how can we educate or how can empower them? How can we empower them? That is my question, sir.
Yes. Aksha Raj, I will give you the answer. I said under our constitutional scheme or under any scheme of law available in the world, rule of law is of prime importance. Rule of law means that your actions shall be judged, appreciated, or opposed only in accordance with the rule, or only in accordance with law. It is not the ipse dixit of an individual officer, howsoever high he is. Law is above him. In continuation of my anecdotes at the beginning of this session, I will now say one more thing. My appointing authority was a divisional engineer, a class 1 officer in Ernakulam in 1968. When I went before him not as an individual telephone operator, but as the secretary of the union in a monthly meeting. At that time, a trade union will have a monthly meeting with the employer where demands will be presented, and the employer, head of the institution, should give us the answer and give us also the minutes of the meeting. That will be a record for us for making further representations to the government. That is all the requirement. But whenever I go there, because I was not a timid person, though he was my appointing authority who had the power to dismiss me, I never budged. I used to put my questions as boldly as possible. And I then said something, because at that time the new telephone exchange was constructed. Without constructing the lift for that, they wanted to shift the telephone exchange to the 4th floor of that building. I told him, if you do this, you will not find the operators for working in the 4th floor. I just simply said, you will not find the operators for working in the 4th floor if you commission the exchange there without providing the lift. Then he asked me, how are you saying so, Mr. Rajendran Nair? You should understand you are only a telephone operator before making such stout observations. He said, yes, sir, I am not here before you as a telephone operator. I am here before you as the secretary of the union, which is 300 and odd strong. I just retorted. And this he took as an insult to him. He retorted by saying, you are saying all this because you have got a law degree. I replied, yes, I got the law degree by burning my midnight oil. This is what I told him. I still remember. It is not your mercy or your charity. That is what I meant. Then he told me, did you obtain permission for undergoing studies while on duty? This was a question which came to me from the divisional engineer. My answer was, sir, please consider whether there was any requirement of a permission. And if a permission is needed, you kindly peruse my personal file, that permission will be there. Because fortunately, because of the episode with the law college principal and the assistant engineer which I narrated, the NOC was issued to me. NOC was in my file. That is the courage which was available with me, because I traveled all the way in accordance to the rule of law and not rule of man. Suppose I had indicated in the application form wrongly that I am not employed on or NIL, then also I would have been admitted. I would have got the law degree. But at this end of the day, I would not have been able to tell you that I was always governed by rule of law. I was sometimes at the mercy of some individual. I think you should not be. No lawyer should be at the mercy of anybody. No individual in this country should be at the mercy of an individual. If that be so, it is rule of man. Just like you find everywhere. Everywhere, when somebody writes a book, when somebody uttered something in the news, man and not matter, which is matters. Rule of law is common for all. Abide by law, however inconvenient it is. And if the law is unreasonable, I will give you the code word: unjust law is no law. Supreme Court has said so in the starting of a judgment on Rent Control Act. Unjust law is no law. And every time when we meet, Mr. Johnson Gomez knows, I always say that law does not enforce impossibility. Law does not impose. These are all laws available in the textbook, rarely practiced. Whenever you find an impossible condition being imposed by an administrator, you will just, what we will do, just, sir, please. That means you show some mercy to me. Mercy, jurisprudence, of course, Justice V.R. Krishna, etc., told about that. That is not the mercy of an individual. Legal mercy is different. That is the mercy petition to the president or the governor as may. Therefore, practice law in such a way that law is supreme. That is why we always say, howsoever high you are, law is above you. That principle you may bear in mind. And if the law cannot save you, none will be able to save you. Suppose I have got some benefit out of the way on consideration of an individual on account of my relationship with him, or on account of my money power, or some other consideration. That won't last long. That is why I emphasize rule of law and not rule of man. Okay, I think Aksha got the message.
Yes, sir. Yes, sir. Clear.
Stand on your footing. And the lawyer should always do that. That is that principle. Because then becomes our approach is a principle-centered approach. You should read one book I will recommend you, 7 Habits of a Highly Successful Man. I don't remember who the author is. I had a copy of that. 7 Habits of a Highly Successful. Ultimately, that book said, you should not be spouse-centered, you should not be money-centered, you should not be other-centered, etc. You should be principle-centered. That is why I say law is supreme. That is why I say rule of law and not rule of man. Okay, thank you. If no question is there, I just conclude. Revati.
Yes, sir. Is there any more questions? Yes.
Revati wants to
Yes, sir. So I'm Revati from Government Law College, Thrissur. So it's not about law. I was wondering that you said while sharing your experience, you coped up with both studies and work. So can you give us some tips on time management that as a law student, I couldn't even cope up with my studies. So how you did that? Can you give us a word on that, sir?
You are employed. Revati, are you employed?
No, sir. No, I'm studying.
See, yes, time, please don't manage time at all. rather allow the time to manage yourself. In fact, when I study, I was having this 8-hour duty in the telephone exchange, which duty I was performing between 16:40 in the evening and 0 hours and 0 to 6:30 hours. That is, which I said, burning my midnight oil, etc. Evening duty and night duty, I could do that. Of course, there I may get some 2 hours rest there. Then I go to the law college by 9:30, sit there up to 3:30. Then some rest. Of course, some classes can be cut also. All classes we needed attend. The professors were so liberal. They used to give us attendance even in absence. Okay. And I had another duty also at that time. I was the trade union leader, having a full-time work. Even after my completion, that is why I delayed my enrollment another 3 years. 68 and 71 only I enrolled. Time is not being managed. Time is being spent usefully. How do you think that it is possible for me to sit before the laptop here between 8 and 9:30 now today? Or even I was prepared by 7:30 because my punctuality warrants me to be present earlier. I don't want to waste others' time. It is not time management. It is realizing the value of time. Only thing is, I will give you one suggestion. If you are supposed to do something today, do it now before you go to sleep. That is exactly the gain which you will get. Do it now theory. This is the auspicious muhurtam. People will think for a very good day to go to a place or to visit somebody, etc. Nothing. Whenever it is, you think of something, do it. Absolutely don't put off. Putting off is a psychology which always we had as a students, putting off, let it be tomorrow. Nale, nile. Adjournment. See, you have heard of adjournment lawyers? You have heard of adjournment lawyers? I think I have never sought for an adjournment in the courtroom. On the other hand, judges have sought adjournments when I start and arguing for 1 minute. Many of the judges have sought, yes, we will have it another day. How can we refuse an adjournment to the judge? I had always told my friends, juniors, please don't go and ask for an adjournment. Be prepared. Be prepared in the classroom or in the courtroom. Always be prepared, except when some new material has to come, or even except when the instructions, otherwise monetary instructions come, you don't seek an adjournment. And anyway, as a senior lawyer, don't go to the court for asking for adjournment. Go to the lawyer only for arguing the case. That is time management. That is the way to achieve what I said. You are saying that is time, because don't be under the erroneous impression that I worked without rest and leisure. Sometimes work itself was a leisure for me, even today. That is why at this time and age, I am happy to share with you because you, Johnson wanted me to have some class. Of course, I suggested this topic, and I could refresh my days with Dr. A.T. Marcos, with whom I sat for administrative law 1969, 70, 71, 2 years for LLM course. My subject was constitution and administrative law. And at that time, even the British decision has not yet come. British decision, which I said that Britain recognized the existence of administrative law in 1971. We were discussing it here much earlier. Dr. A.T. Marcos, his book is Judicial Review of Legislative Action, Judicial Review of Administrative Action. What those books are there. Very wonderful law it is. I just tell you're all practicing in criminal law at least. Criminal law, there is an appeal. Whenever I read, I just read when I am briefed for a criminal law appeal, I first asked for the 313 statement. What do you know what 313 statement is? Criminal Procedure Code, Section 313. It provides the biggest principles of natural justice, which is available in administrative law, that every accused must be given an opportunity to answer the circumstances arising in evidence against him by putting questions. Therefore, I read the 313 first even in the open court. And Mr. Justice Kamal Pasha's court, I read only that and said that a volume of evidence is there in this case, and everything is discussed by the judge in the judgment, but none of those questions were put to me. Therefore, I did not get an opportunity to explain the circumstances which are against me. Those circumstances are now utilized against me. That is violative of not only principles of natural justice, but also the statutory provision under Section 313. This was the only argument in a very difficult, typical criminal case. Many judges won't accept. Kamal Pasha did it. As a judge, he was such a studious, astute judge. My appeal was allowed, saying that though there is much evidence on record, and much evidence is recorded by the Sessions Court, I find nothing in the 313 statement. Therefore, the judgment is set aside. Matter goes back to the trial court, CJM court. Again, of course, further questioning took place. I don't know how it ended last. I say possible to practice administrative law in a criminal court appeal. And the statutory provision of administrative law is available in our CRPC 313. Do you know how CRPC is, how old it is? Not it is 1973. Today you will find it 1973. It was not 1973, much earlier. Therefore, the legal principle that no man shall be punished unheard was recognized in Criminal Procedure Code. Later on only we speak about administrative law, etc. Nothing. After all, it is just fair, and being just fair and reasonable is the basic principle of administrative law. Okay? So, any other question?
Okay, sir. I believe, yes. Is there any other questions from the participants? One more question.
Questions will not be there from those who have understood everything and much more than what is spoken. And questions will not be there from those who have not understood anything. Which category you fall? Yes, Dilip, do you want to ask something? No.
Me, sir? Dilip, yes, Dilip. Sir, can you kindly unmute yourself, Dilip, sir? Unmute yourself.
Sorry, sir, I just logged in only now, and I heard the last part.
I see.
I did not come to know about it.
Okay, I believe there are no questions.
Yes.
And we have reached our time.
Yes. Enough viewers. Now we can conclude now.
Yeah. Thank Rajendran for also. And only recently recognized the fact that I it takes syllabus. It's 2 semesters complete administrative law. When it's specialization of LLM, I also take up more than 1 semester. To its quality and its application. These are with gone to the ethical administrative law. It's the application in our day-to-day life by younger in student, employer, employee, government. So in of administrative by the institutions and how they are animated by the legal practitioners in order to provide the remedy for ordinary men. How administration ensures that executive does not overreach and curtail the fundamental freedoms, fundamental rights of its citizens. Rather, it promotes the scope of fundamental rights. He has eloquently explained, elaborated, and I am very sure that through his presentation, he has, given, he has promoted many of the young lawyers to apply what they have in their classroom with regard to administrative in their day-to-day life as well as in their legal practice. Thank you, Rajan, sir, for the wonderful presentation. And we hope to see you again. We hope to see further cooperation from your side to make Project Complete Lawyer a success. I also thank John sir, chairman of Project Complete Lawyer, who behind the successful running of the program. I also thank who also lawyer realization. I also all participants from for listening and participating. Thank you all. Have a good night. The session has been concluded.
Okay, thank you.
Good night. Good night.
Thank you.
Hello, Sandeep sir.
I'm on the shop.
സാറേ സൗണ്ട് ബ്രേക്ക് ആവുന്നുണ്ട്. എങ്ങനെയാ സർ സ്റ്റോപ്പ് ചെയ്യുന്നത്? ഞാൻ കോൾ ചെയ്യാം സർ.